Michigan Agency Disclosure Requirements. Question 1. During a renewal review in Marquette, a branch manager encounters a rule involving the total continuing education expected within a full 3-year cycle. Which response follows Michigan law, while the file concerns a farm parcel, a title commitment, and a confidential price limit? Option A. At least 40 clock hours. Option B. At least 18 clock hours. Option C. At least 6 clock hours. Option D. At least 12 clock hours. The correct answer is option B. At least 18 clock hours. A full renewal cycle requires 18 hours of eligible professional education. The transaction context changes the facts, but it does not change the underlying licensing duty. Pre-licensure coursework cannot simply be relabeled as renewal credit. Question 2. A licensee is preparing for a property management meeting in Pontiac. Which statement correctly addresses the annual law minus related continuing education component, while the file concerns a lakefront cottage, a seller net sheet, and a change of employing broker? Option A. No annual subject requirement. Option B. 4 hours of appraisal each year. Option C. At least 2 hours involving laws, rules, and court cases. Option D. 1 hour every 3 years. The correct answer is option C. At least 2 hours involving laws, rules, and court cases. Each year of the license cycle includes a real minus estate law component. A written office procedure should produce the same result in comparable transactions. General elective hours do not replace the designated legal instruction. Question 3. Which Michigan requirement should control when a salesperson deals with the annual fair minus housing continuing education component during an advertising campaign, while the file concerns a townhouse, a property condition statement, and an owner minus licensee conflict? Option A. At least 1 hour involving fair housing compliance. Option B. 3 hours of advertising only. Option C. 1 hour of tax preparation. Option D. No fair minus housing instruction after licensure. The correct answer is option A. At least 1 hour involving fair housing compliance. Housing minus equality instruction remains an annual part of professional education. In the described setting, the brokerage should document the step and apply it before moving forward. A general business course does not satisfy this designated subject by itself. Stressed about your real estate? We can take real estate for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 4. At a transaction minus file review, the brokerage discusses the timing of continuing education in relation to online renewal. Which conclusion is most accurate, while the file concerns a urban infill property, a property management ledger, and an expired license issue? Option A. Finish the required education before submitting the renewal. Option B. Renew first and complete education later. Option C. Complete education only if audited. Option D. Substitute a new licensing examination. The correct answer is option A. Finish the required education before submitting the renewal. The licensee must be able to truthfully attest to educational compliance during renewal. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. An audit is a verification mechanism rather than the event that creates the obligation. Question 5. A compliance question in Grand Rapids concerns the record minus retention period for proof supporting a continuing education certification. Which action or statement is appropriate, while the file concerns a subdivision lot, a title commitment, and a property minus management payment? Option A. Until the license card arrives. Option B. 1 year after the course. Option C. Permanently with the county clerk. Option D. At least 4 years after the certification date. The correct answer is option D. At least 4 years after the certification date. Licensees are responsible for keeping acceptable evidence of completed renewal education. For exam purposes, focus on the regulated relationship rather than an informal business custom. Course providers or local offices do not replace the licensee's documentation duty. Question 6. How should a Michigan buyer representative handle a situation involving the consequence of a license being revoked before a new application, while the file concerns a rural acreage, a seller net sheet, and a delayed possession term? Option A. Complete only a transfer request. Option B. Wait at least 3 years after service of the final order. Option C. Reapply immediately after paying a fee. Option D. Wait 30 days. The correct answer is option B. Wait at least 3 years after service of the final order. Revocation creates a statutory waiting period before a new license application. The transaction context changes the facts, but it does not change the underlying licensing duty. A routine transfer or fee payment cannot bypass the sanction. Question 7. Which choice best applies the state rule concerning the education calculation for relicensure when expiration was less than 3 years ago to a compliance interview, while the file concerns a single minus family residence, a property condition statement, and a cooperating brokerage? Option A. No education is required. Option B. A complete 40 hours for every missed month. Option C. Complete 6 hours for each elapsed year or partial year. Option D. Repeat only the original exam. The correct answer is option C. Complete 6 hours for each elapsed year or partial year. Recent relicensure uses a year minus by minus year continuing education calculation. A written office procedure should produce the same result in comparable transactions. The original salesperson course is not automatically the only route in this situation. Question 8. A file from Muskegon raises an issue about the additional choices after a license has lapsed for 3 years or more. Which answer identifies the governing requirement, while the file concerns a small apartment building, a property management ledger, and a rejected counteroffer? Option A. Meet the stated relicensure education or examination pathway. Option B. Pay a late fee only. Option C. Use an employer transfer without review. Option D. Reactivate through a local association. The correct answer is option A. Meet the stated relicensure education or examination pathway. A long minus expired credential requires more than a routine renewal transaction. In the described setting, the brokerage should document the step and apply it before moving forward. Local membership does not restore state authority to practice. Are you looking for real estate actual questions? Visit our website pokerexams.com to access real estate study guide with actual questions and answers. Scan the QR code or click the link in the description to get real estate answer key today. Question 9. Before completing a seller consultation, which rule should the new applicant apply to the source from which a salesperson may accept brokerage compensation, while the file concerns an office condominium, a title commitment, and an assumed business name? Option A. Any cooperating salesperson. Option B. A home inspector. Option C. The employing real estate broker. Option D. A buyer directly without broker involvement. The correct answer is option C. The employing real estate broker. Salesperson earnings for regulated activity flow through the employing brokerage. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. A transaction participant cannot bypass the broker by paying the salesperson directly. Question 10. A Michigan exam candidate reviews a scenario involving payment of commissions earned before a salesperson left a brokerage. Which option reflects the current licensing framework, while the file concerns a condominium unit, a seller net sheet, and a security minus deposit question? Option A. Payment is allowed only after relicensure. Option B. The money must be forfeited. Option C. The new broker must collect it first. Option D. The former broker may pay the income that was earned during employment. The correct answer is option D. The former broker may pay the income that was earned during employment. Compensation already earned under the former employment relationship may still be distributed afterward. For exam purposes, focus on the regulated relationship rather than an informal business custom. A later transfer or licensing change does not automatically cancel earned income. Question 11. The broker's policy manual addresses the ability to sue for a brokerage commission. Which provision should it contain, while the file concerns a retail suite, a property condition statement, and a dual minus representation concern? Option A. Only the buyer's signature is needed. Option B. Licensure must be alleged and proved for the regulated services. Option C. An oral advertisement establishes entitlement. Option D. A license is irrelevant in a compensation action. The correct answer is option B. Licensure must be alleged and proved for the regulated services. A person seeking judicial recovery for regulated brokerage work must establish lawful licensure. The transaction context changes the facts, but it does not change the underlying licensing duty. Advertising or a participant's signature cannot replace occupational authority. Question 12. A regulator asks about the size of the employing broker's business name in an advertisement featuring a salesperson or team during a brokerage review. Which response demonstrates compliance, while the file concerns a manufactured home site, a property management ledger, and a protected minus class inquiry? Option A, smaller than every team name. Option B, equal to or greater than the affiliated name. Option C, omitted if a logo appears. Option D, shown only after a consumer clicks. The correct answer is option B, equal to or greater than the affiliated name. Michigan advertising must make the responsible brokerage meaningfully visible. A written office procedure should produce the same result in comparable transactions. A logo or later webpage does not cure an initial display that hides brokerage identity. Question 13. Which statement would be safest for a salesperson to follow when the contact information required in a broker's real estate advertisement becomes relevant, while the file concerns a 2-unit rental, a title commitment, and a disputed repair credit? Option A, the salesperson's birth date. Option B, a lender's routing number. Option C, the broker's telephone number or street address. Option D, only a social-media username. The correct answer is option C, the broker's telephone number or street address. Broker advertising must provide a direct identifying contact element for the licensed firm. In the described setting, the brokerage should document the step and apply it before moving forward. Personal data and unrelated account information do not serve the regulatory purpose. Question 14. A dispute arises during a brokerage audit over the business identity under which a salesperson generally advertises. Which principal resolves the issue, while the file concerns a historic residence, a seller net sheet, and an electronic signature? Option A, a private unregistered trade name. Option B, the salesperson's name alone for every listing. Option C, the title company's name. Option D, the employing broker's business name and supervision. The correct answer is option D, the employing broker's business name and supervision. Affiliated licensees market regulated services through the employing brokerage. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Personal branding cannot displace required brokerage identification. Question 15. In Saginaw, an employing broker must decide how to proceed with advertising a salesperson's own principal residence for sale. Which decision is consistent with Michigan requirements, while the file concerns a student rental, a property condition statement, and a referral arrangement? Option A, no advertising is permitted. Option B, the salesperson may advertise it under the salesperson's name while disclosing licensed status as required. Option C, the salesperson may conceal licensure. Option D, the property must be listed by a different broker. The correct answer is option B. The salesperson may advertise it under the salesperson's name while disclosing licensed status as required. Michigan provides a narrow personal minus property advertising exception for a salesperson's principal residence. For exam purposes, focus on the regulated relationship rather than an informal business custom. It also does not create a general right to market unrelated properties independently. Question 16. Which exam answer accurately classifies the rule involving advertising rental property personally owned by a salesperson, while the file concerns a vacant commercial parcel, a property management ledger, and a team social-media post? Option A, the salesperson must surrender the license. Option B, the property becomes brokerage trust property. Option C, the salesperson may advertise the owned rental under the salesperson's name. Option D, only a county official may advertise it. The correct answer is option C. The salesperson may advertise the owned rental under the salesperson's name. Ownership creates a limited exception for marketing the licensee's own rental property. The transaction context changes the facts, but it does not change the underlying licensing duty. The exception does not authorize independent advertising for property owned by others. Question 17. A new policy is being drafted for a broker adopting a lawful assumed business name. Which language belongs in the policy, while the file concerns an industrial site, a title commitment, and a record inspection request? Option A, wait until the next property closes. Option B, use it indefinitely without notice. Option C, register it only with the local MLS. Option D, notify the department with the application or within 30 days after adoption. The correct answer is option D, notify the department with the application or within 30 days after adoption. A brokerage trade identity must be connected to the state licensing record. A written office procedure should produce the same result in comparable transactions. Private database registration does not replace the department filing. Question 18. During team training, the supervising broker tests knowledge of a lottery or prize plan used to promote the sale of a specific parcel. Which answer should the team select? While the file concerns a new construction home, a seller net sheet, and a branch minus office distance issue. Option A. It is mandatory for new listings. Option B. It replaces fair minus housing compliance. Option C. The plan is generally prohibited for direct promotion of that property. Option D. It is allowed whenever a salesperson pays for it. The correct answer is option C. The plan is generally prohibited for direct promotion of that property. Michigan restricts games and drawings used directly to sell a particular piece of real estate. In the described setting, the brokerage should document the step and apply it before moving forward. Who funds the promotion does not remove the statutory concern. Stressed about your real estate? We can take real estate for you remotely and undetected. We always guarantee a pass and payments only after results. To send us an email, scan the code or tap the link in the description and let's get it done. Question 19. A consumer asks the brokerage to explain regular contact between a broker and salesperson. Which explanation reflects Michigan law? While the file concerns a mixed minus use building, a property condition statement, and a financing contingency. Option A. It is part of the broker's required supervision. Option B. It is replaced by customer reviews. Option C. It may be prohibited by contract. Option D. It is optional after the first closing. The correct answer is option A. It is part of the broker's required supervision. Supervision includes direct communication through in-minus person or electronic means on a regular basis. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Private contracts cannot remove the broker's statutory oversight role. Question 20. Which compliance step is required when the transaction facts involve reviewing a salesperson's practice and transaction reports, while the file concerns a cooperative unit, a property management ledger, and an unrepresented consumer? Option A. It occurs only after a complaint. Option B. It is a required supervisory activity. Option C. It is performed only by the tax assessor. Option D. It is unnecessary for independent contractors. The correct answer is option B. It is a required supervisory activity. Broker oversight extends to how the salesperson performs regulated work and reports activity. For exam purposes, focus on the regulated relationship rather than an informal business custom. Independent minus contractor classification does not cancel licensing supervision. Question 21. A branch manager notices a potential problem involving providing written operating policies and procedures. Which response should occur first? While the file concerns a farm parcel, a title commitment, and a confidential price limit. Option A. It is part of adequate salesperson supervision. Option B. It is optional if the firm has a logo. Option C. It may be delegated to a buyer. Option D. It is prohibited as legal advice. The correct answer is option A. It is part of adequate salesperson supervision. Written policies give affiliated licensees consistent directions for regulated activity. The transaction context changes the facts, but it does not change the underlying licensing duty. Branding or client instructions cannot replace internal operating guidance. Question 22. The state portion of the exam presents facts about a contract clause that removes the broker's authority to supervise a salesperson. Which result is supported? While the file concerns a lakefront cottage, a seller net sheet, and a change of employing broker? Option A. The clause is required for contractors. Option B. The clause is valid if notarized. Option C. The clause is not permitted. Option D. The clause transfers supervision to the seller. The correct answer is option C. The clause is not permitted. Employment wording cannot strip the broker of statutory supervisory power. A written office procedure should produce the same result in comparable transactions. Notarization does not validate a provision that conflicts with licensing law. Question 23. Which brokerage practice properly addresses an additional Michigan place of business maintained by a broker in the Muskegon transaction, while the file concerns a townhouse, a property condition statement, and an owner-minus-licensee conflict? Option A. A branch office license is required. Option B. Only an MLS subscription is required. Option C. The location is automatically covered forever. Option D. The salesperson obtains a separate broker license. The correct answer is option A. A branch office license is required. Each additional brokerage location must be connected to an authorized branch office. In the described setting, the brokerage should document the step and apply it before moving forward. A membership account or salesperson credential does not license the location. Question 24. A licensee is comparing 4 procedures related to a branch office located more than 25 miles from the nearest boundary of the main office municipality. Which procedure is lawful, while the file concerns a urban infill property, a property management ledger, and an expired license issue? Option A. No supervision is required. Option B. The branch must close permanently. Option C. A customer may supervise the branch. Option D. An associate broker must provide direct supervision at the branch. The correct answer is option D. An associate broker must provide direct supervision at the branch. Distance from the main minus office municipality triggers an enhanced branch minus supervision requirement. Applied to this scenario, the licensee should follow the rule before creating further obligations for a party. Remote availability alone does not satisfy the stated arrangement. Question 25. At the end of a listing presentation, the parties question the physical minus location requirement for an individual broker, broker company, or branch office. Which statement provides the best guidance, while the file concerns a subdivision lot, a title commitment, and a property minus management payment? Option A. Use the address of any salesperson. Option B. Operate without a listed location. Option C. Use only a post minus office box anywhere. Option D. Maintain a physical address in Michigan. The correct answer is option D. Maintain a physical address in Michigan. Brokerage offices must have an identifiable Michigan business location. For exam purposes, focus on the regulated relationship rather than an informal business custom. An unrelated person's address cannot stand in for the licensed office.